Our next guest is one of the best attorneys in the business, Mr. Matthew Eichelberger. Matt began practicing law in 2023 and became the Assistant Public Defender of Washington County in Mississippi in 2024. He's an MCOBS board member and is doing a great job. Let's welcome no other than Matthew Eichelberger.
Thank you. I appreciate it. Good to be here. So, just a minute ago, I was sent something by a friend that's actually really funny, and I want to try to share it with you. I don't have it on my computer yet, on my laptop, so give me just 1 second, and I will see if this will play.
Split the pot, 50-50. This is the last call. If you want some, raise your hand, we'll come see you.
I'm not going to be able to get it to work. I'll tell you a funny story instead. All right. So, what we're going to talk about today is kind of what happened to the legislature over the past few months and some laws that are going to go into effect that will affect what you do for a living, and then some of the things that failed. The reason I talk about the things that failed is because sometimes it will give you an indication as to what's going to come. You may remember last session in 2024, Senator Joey Fillingane raised a kind of a reform package for bond and bail issues, and it didn't pass, right? There were some things that would have been clarified there that would have been helpful to everybody here, but it failed, and then this year it passed. So it's important to kind of look at some of these things that might be on the horizon, and we'll do that now. But before I get into that, I want to tell y'all how excited I am that I am the proud owner of a taser now. I won that last night in the silent auction. Nobody in my office is excited, but I am. Sometimes, I do primarily criminal defense. Sometimes I sue bad cops. People say, oh, he sues cops. I don't. I sue bad cops, and I proudly do that. And I cannot wait for the opportunity to be in a deposition of one of these officers who's tased somebody to death, or they're expert, and then now I get to offer up the opportunity for them to show us just how safe and painless it is. Because that's what they always say, oh, it's safe, it's less than lethal, it's totally fine. Anyway, that brought to mind a story from Racehorse Haynes. I don't know if any of y'all ever heard of Racehorse. Racehorse was one of the greatest, if not the greatest, criminal defense lawyer to ever live. He died a few years ago. He was a Texan. I practiced law for a little while, early in my career out in Texas, and knew about Racehorse through that. Racehorse one time was defending a biker gang that was accused of using a cattle prod to kill somebody, that they shocked them to death. It was cattle prod. And Racehorse thought that was bunk. He went out, found an expert that said it wouldn't even kill a chicken, let alone a human. And so the prosecution has what they think is the murder weapon there with them in the courtroom as the trial's going on. And Racehorse isn't messing with it, and he figured out that if he went to the butt of it, right, and unscrewed the cap, he could slide a dime in there, screw it back together, and it would short it out, right? It would still make the buzzing sound, but it wouldn't actually deliver any current. So he figures this out, and he gets up in front of the jury, and, he gets up in front of some reporters, right, saying, this thing ain't nothing, it doesn't hurt anybody. He held it up to his neck and shocked himself in the neck with it, right, or at least that's what they thought. And then when everybody's out of the courtroom, he goes and takes the dime out, puts it back together, and leaves it there. Well, the prosecutor decided, well, if Racehorse is doing this, I'm going to try it. And so he gets up in his closing, he's in front of the jury, and he's over by the box, and he shocks himself in the arm with it and knocks his ass into the jury box on top of the jury. So, it's a funny story, and I'm very excited to have my own taser now. Let's talk about some things that died this year. Some of these bills that were introduced didn't make it out of there. The first one, Senate Bill 2199, Senator Boyd brought that to us. It was referred to Senate Judd A and died there without a vote. Oftentimes, that's a good indication that something's probably not ever going to go anywhere. But this one would have required a cooling off period before a person charged with domestic violence could be released from jail. And that would be required. Every person, no matter really the proof or anything, misdemeanor domestic violence all the way through ag domestic, would have to sit for a period of 24 to 48 hours set by the judge, right, before they could be released. Also would have required GPS monitoring for every domestic violence defendant. And I know that there are a lot of municipalities that kind of do that by default now, but this would have been statewide. There are some obvious constitutional concerns with that, and I think that's why the Judd A committee never even brought it up. There was also provisions in there for the victim to say, all right, I don't want this defendant in these locations, right? Well, that creates a whole other set of problems potentially as well, because they would say, I don't want them at my house, I don't want them near my job, I don't want them near their job, right? They could cause a lot of havoc with that. So that died, and I don't know that we'll ever see that come back up. House Bill 891, Justice Gibbs, representative out of Hinds County, he brought that one up. It was referred to House Judd B, and it died there without a vote too. This was interesting. It would have required that defendants go back into custody when their bonds expire after 3 years. Obviously, that would have been a potential for a source of new premiums. Basically, you would have to renew every bond at the end of 3 years, which is particularly a problem in Hinds County with a system that moves as slowly as it does. I thought that was very interesting that the son, his dad was a former circuit court judge in Hinds County, and his mom is a current circuit court judge in Hinds County. I thought it was interesting that he was the one that brought that up. So it would have been a source of potential new premiums, but it also would have been a pretty big logistical nightmare, I would think, for everybody, because you have to, at the end of these 3 years, you have to be tracking them and then figuring out, do we have to renew it? Do we not have to renew it? And it would require the original court to answer the question. So if somebody in Jackson Municipal Court sets the bond, the person bonds out, well, now Jackson Municipal Court has to take on the issue 3 years later, even if it's been indicted and they technically have lost control over the case. So it was kind of a mess, but I don't think that one's ever coming back, but it was an interesting idea. House Bill 677, Representative Randy Rushing wrote that. It was referred to Judd A in the House, and it died without any action as well. It would have kind of provided some guidance, I think. It would have helped y'all. There is the provision, that says there's a statute that says what bail agents can and cannot do, right? And it says you can't, recommend a certain attorney. You can't bribe police officers or judges, right? There's all these things you can't do, and one of them is you can't give legal advice, right? Well, what's legal advice? And the statute basically says any legal advice whatsoever. It's just a very broad statute that's problematic. And this bill would have done, I think, a good thing, which is say you can't essentially practice law without a license, right? And it referred to another statute that defines what that is. So it would have been okay for you to, you could do this without any fear. You could say, all right, well, this is what this hearing is about. This is what you can expect. This is how this judge normally does these things, right? You could share your experience with your client without any problem and without any fear. Unfortunately, that died. But maybe it can come back around in the next session next year. House Bill 1484 was an interesting one. Representative Keene authored that. That was the Mississippi Illegal Aliens Certified Bounty Hunter Program. That got a lot of press. Y'all probably heard about that one. And his idea was, all right, we're going to create this program where bail agents can be certified to go be bounty hunters for illegal aliens, okay? That's an interesting concept. There would have been payments, bounty payments from the state for the successful capture of illegal immigrants. It also was going to set up an anonymous tip line. And being a lawyer, I can't help but think of all of the problems that this would create, right? So I call the anonymous tip line because I don't like my neighbor, right, whose daughter's dating some brown-skinned boy I don't like, right? And I call in to say he's illegal. Well, one of y'all has gone through the program. Okay, we've got a tip that, this guy over here ain't here illegally. Well, you go and you arrest him under this program and you bring him in. And guess what? Natural-born citizen of natural-born citizens of natural-born citizens, right? Guess who's liable for that? You would be. You would be. And, of course, this bill tried to put immunity protections in there, and that is fine because I wouldn't sue in state court. I wouldn't have anything to do with that. I'd sue you in federal court. And I would sue you under Section 1983, and you wouldn't have the protection of qualified immunity. Your butt would just be hanging out over the line, completely exposed. So there was a lot of problems with that bill. Sometimes it got double referred by House leadership. That means they hate it. Okay, whenever you see a bill double referred, meaning it gets sent to two different committees, that means that the leadership of that legislative body dislikes that bill and does not want to see it pass. Okay, so there are obviously some issues with immigration. This is probably not the way to go about it, and it doesn't appear that this was anything other than a publicity grab for King. So let's talk about referrals for a second and a little bit of legislative kind of inner workings. So back in 2007, when I moved back from Texas, my best friend was elected to the legislature from the Gulf Coast, Brandon Jones. He's been to some functions before in the past with y'all. So Brandon gets elected, and he's living up there with me, Michael Watson, who you heard from earlier today. He and I went to law school together. We met first day. We met at orientation for law school. We're in the same section. He got elected at the same time, also from Pascagoula. He was sent to the Senate, and Brandon was sent to the House. So being around Brandon and those guys, I learned a lot about how this stuff works. I spent a lot of time in the literal smoke-filled rooms. Billy McCoy was the speaker at the time, and he had a hotel room at the Holiday Inn on High Street, and around about 9 o'clock every night, the call would go out, hey, let's go to the speaker's room. So I'd go tag along over there and bring some cigarettes and some beer, and we'd sit down and we'd talk about what all was happening. And early on in the session, when all these bills are written, they get referred to committees. The speaker and his people on the House side, and the lieutenant governor and his kind of inner circle on the Senate side, they decide where those bills are going to be referred, right? And when a bill gets referred to a committee, it has to get passed out of that committee in order to make its way to the House floor or the Senate floor, wherever it may be. So it's got to clear that hurdle, and then it's got to get voted out of the chamber and sent to the other chamber where it gets assigned to a committee, and then that committee has to pass it out, and it has to pass that chamber, and then if there are differences, it goes to the conference committee. That's how the system works. So when a bill gets double referred, when you ever hear that, what that means is it has to pass out of both committees, which is just hard to do. But that's where you send things to die, is double referring. So if you ever see that happen in the future, you know what's going on. All right. Now let's talk about, we're getting into some things that did pass. So House Bill 1285 and 1286, those two, Elliot Birch and Representative Hall, Birch and Hall wrote those. It's the House version of what became, or what passed, what became law through Senate Bill 2315. So Senate Bill 2315, I mentioned Joey Fillingane earlier. He wrote the same legislation essentially last year that failed. And this one, it passed. So it puts into statute now that forfeitures must be set aside if a surety wasn't notified of the defendant's failure to appear, right? It's no longer a question as to whether or not it gets set aside. It's now statute. It has to be set aside. It goes into effect July 1. So it clarified also through a new statute, section 99541, when a bond is to be discharged. Okay, and we'll walk through that with you now. It kind of makes sense, but some things that make sense don't always make sense to clerks, and so now they know. First, if they're found guilty and sentenced, discharged. If the charge is dismissed or null prossed, discharged. Remanded or passed to the files. And these are fun terms, right? Because prosecutors say, well, it's remanded. Well, what does that really mean? Right? And sometimes they just say remanded without any condition. Well, what does that mean? It means we're not going to prosecute it anymore, I guess? It's coming off the court's docket? Well, why not just enter an order of dismissal or null pros? Anyway, if it's remanded or passed to the files, you're off the hook. If the defendant is surrendered, you're off the hook. And here's the one that I think has caused some problems. Those of you in Hinds County, I think we've seen this from time to time. If a person enters PTI, pretrial intervention program, non-adjudication, I think that one's kind of self-explanatory, or any other alternative sentencing program, like a drug court, something like that. Now it's clear as a bell, you're off the hook, period, you're done, okay? There's also, I'm sorry, thought I had a question. There's also, what's that?
He was cheering.
Oh, okay, yeah. Well, I had nothing to do with it. I'm just here delivering the news. Y'all call Joey and thank him. So another thing that's interesting and helpful, I think, felony failures to appear now have to go on NCIC, and they have to be without restriction. Because, you know, a warrant can be placed in NCIC, and then they'll say, but only if in Mississippi, right? And that's a problem, because let's say a guy runs off on some bad checks or something. He runs off to Texas or Utah or wherever, and he's on NCIC, and he gets pulled over, and they see it, but it says, you know, will not extradite. So then they're going to let him go. And so you've had law enforcement contact with that dude who ran out on y'all, and he just gets to keep on running, right? So I think that's very helpful. Let's see, another part, and this is the final part of it that I think is pretty excellent. It mandates that you have time and opportunity to submit proof that a defendant has been surrendered or that the bond has been paid before the Department of Insurance can revoke your license. So I know that would never happen to anybody in this room, and is probably going to just provide some protection for folks that maybe need to get out of the business, right? But it's there. As a lawyer, I like process. It's part of what I do for a living, right? It's making sure that people have due process. Literally swore an oath multiple times to try to provide that to everybody, civilly and criminally. And so I'm glad that this is there. It stretches it out now. I want to say it's 18 months. You can like have a look back period where you can say, nope, found them, got them, or hey, we paid the bond, and they have to put you back in. So that's a look at what all happened in the legislature. There's another thing going on right now that I want to touch on because you're about to see it. Yesterday, McCutcheon, the chief of police up in Oxford, was interviewed by Richard Cross on Super Talk. And he was talking about these Delta 9 and Delta 8 THC products you see on store shelves everywhere. By the way, they're having their convention down here somewhere right now. The chiefs of police are. So anyway, he was interviewed, and there was a Maggie Kate Bobo at the AG's office wrote an opinion from a request from Lee Yancey in response to that request from Lee Yancey, basically saying, hey, is this enforceable? Like, if this stuff is in stores, right? And by the way, this stuff's real. I mean, this is not a joke. Used to, you would see like the weed van rolling around New Orleans or whatever, and that stuff was fake. It did not get you high. It was just a gimmick, right? It smelled kind of like it, but there was no physical effects whatsoever. Well, 2018 Farm Bill passed and created a massive loophole. Unbeknownst to Congress at the time, about 6 years prior, a scientist, I think it was at Caltech, had figured out a way to take the very low concentration of THC that is found in what we call hemp, right, and basically extract it cheaply and easily into a usable form. So the Farm Bill said, okay, look, we want to do things to help out the hemp industry in America. So we're going to say it's totally fine and federally legal so to grow hemp, to sell it, to make products with it, to do whatever you want to do, okay? So long as the concentration of THC is below a certain level. It's like 0.03%. By dry weight, I do not pretend to understand how it's measured. But what they essentially said is below this line, it's fine. Again, not knowing or understanding that people are going to start making legit THC, Delta-9 THC, get you high vapes, edibles, drinks, the whole nine. And an industry sprung up. And every state has tried to figure out what to do with it, and they keep running into roadblocks. And they're trying to figure out what to do with it because you could just walk into a store and walk out with a 4-pack of cans. They'll get you pretty blasted, okay? It's just mind-numbing to me that this happens in Mississippi. I can walk into the gas station over here and walk out with enough to get everybody in this room high. So it's just, again, it's shocking to me. I'm not passing judgment on either way. I'm just shocked by it. So every state's dealing with it, and they keep passing laws trying to prohibit it, and they keep running into problems because of this thing called preemption. If the federal government says you can't do it, then you can't do it. You don't get to just decide, I'm not going to listen to this part of what the federal government tells me to do. So the federal government said, this is legal, okay? This is legal. And so now these states have tried to go back and say, well, no, it's not under our laws, therefore we're going to go arrest these people, we're going to prosecute these people. Well, federal judges keep shutting them down left and right. Arkansas did it a few months ago, I think September, so I guess more than a few months ago now. Arkansas did it. It's going to happen in Mississippi because Maggie Kate Bobo, in a very well thought out response, talked about what the state law is. Okay, and I'm going to tie this back to McCutcheon in a second. Talked about what the state law is. So now law enforcement's walking around with their chest puffed out saying, we're going to go start enforcing this law. And that's what McCutcheon talked about yesterday. He said, we're down here right now, we're discussing it. You're going to see enforcement begin almost immediately. Okay, so they're going to start arresting store owners. They're going to start arresting clerks, although they've been doing that in Southwest Mississippi. You're going to see this effort to enforce it, and then you're also going to see lawyers pushing back and taking them to federal court, and I think it's going to get shut down. At some point, we've got to figure out what to do with it, but that's a policy discussion that's way above my pay grade. That's why we pay taxes, so those people can figure it out. But anyway, you're going to start seeing that. It's going to be kind of an interesting time because these aren't going to be your typical folks that are possessing drugs, right? These are going to be entrepreneurs. They're going to be business people. They're going to be community leaders, icons. They're going down. Like they're going to start arresting them this weekend is when I think it's coming. So just FYI, be on the lookout for that. I don't have anything else to talk with you all about. I'm the last speaker. I'm going to go ahead and shut it down. And I got it done pretty quick, Charles, I think. If you have any questions, just ask me privately so we don't take up everybody's time because we're at the end. So thank y'all. I appreciate it.